start the recording, that would be great. Good afternoon, everyone, and welcome to today's webinar. First of all, thank you for joining us. This session is tailored specifically for professionals like you. Whether you are a risk manager, construction manager, or project engineer, we all know that in today's environment, what gets written can and often does resurface later in claims, disputes, and audits. Especially in the public sector where transparency and accountability are paramount, the way we communicate on paper, via email, or even in a text message can have very long-lasting impacts. Construction projects in the water and wastewater sector are complex, high stakes, and often subject to intense public scrutiny. Add to that the layers of consultants, contractors, regulators, and attorneys, and suddenly a single poorly worded email or comment in a field report or in a text message or in an email can end up as an Exhibit A in litigation or a board inquiry. This session isn't about scaring you into silence. It's about empowering you to write and document with awareness. We'll explore best practices for written communication, real-world examples of how innocent comments have been misinterpreted or misused, and strategies to document facts clearly, professionally, and defensibly. Our presenters today bring deep legal, construction, and public agency experience to the table. We're fortunate to be joined by two outstanding experts from Nossaman LLP. First, we have David Lee, Chair of Nossaman's Litigation Group. David brings over 25 years of litigation experience, including significant work in disputes involving construction claims in water and wastewater facilities. His practice spans complex commercial matters, including real estate, technology, and public sector disputes. He regularly advises public entities on contractual rights and litigation strategy and understands the unique landscape in which our agencies operate. Joining him is Jill Jeffy, who leads Nossaman's construction claim team. Jill has deep experience in construction litigation, public contracting, and procurement disputes. She represented public clients across multiple states in high-stakes infrastructure projects and has handled everything from bid protests to delay and disruption claims and disputes over utility relocation, right-of-ways, environmental permitting, and more. Jill is a trusted advisor when it comes to navigating the nuances of written documentation in public work projects. Together, David and Jill will help us unpack how even routine communication can become critical pieces of evidence, and how to write in a way that supports your agency's positions rather than undermines it. So again, thank you for being here, and let's get started. David?
Thank you all very much. I'm going to go ahead and put a presentation up there. And can everybody see that okay?
David,
Yes.
we can.
Yes, that's
Excellent.
great. Thank you.
Well, perfect. So we're going to go ahead and get started. And I think, Jill, you're going to go ahead and kick us off.
Kick us off. So thank you so much for the introduction, Vlad. And it's really a pleasure to be here today and talk to you about subjects that we deal with every day, and look forward to answering questions too at the end of the presentation. But so just a little bit more about us. One thing that makes Nossaman unique with respect to water infrastructure projects is the length of our touch points. So we have professionals who interface with water infrastructure projects, water infrastructure clients, starting with legislation and funding through the environmental compliance process, procurement, all the way to construction claims. And David and I both interface with our colleagues on these various issues and bring that knowledge and expertise to the work and experience that we have with our clients. And I think also this depth of expertise also informs how we view documentation on the projects. With some of our clients, we really get into the weeds and work with them to ensure that, one, they aren't creating records that they're not going to want to see later, which David's going to talk to you about in length, but also, two, create documentation that will really help protect them if there are claims down the road, which is particularly important for novel projects or really complicated big projects. Next slide, please.
All right. There we go.
Thanks, David. These are some of the recent water infrastructure projects David and I worked on. I actually personally have touched all three of these projects. And I want to highlight this for you, as you all know, because you're in the water industry. The water industry is a very exciting place to work. We are very lucky to work with our water clients. There are so many new and innovative projects, but with that innovation comes unique and new challenges. And so part of the presentation today is talking about documentation in that light, because you don't know every issue that's going to come up on a project, such as, San Diego's Pure Water Project, which is the first pure water program in the state. And so it's important to be proactive and pragmatic when you're approaching administration of these contracts. And with that, David, back to you.
Excellent. Well, thank you. So the way that we've kind of structured this program is to kind of take you through, obviously, certain risks, with employee behavior. And so we've kind of broken this up into 4 different sections. Really kind of imprudent communications that may be discovered, as Vlad had alluded to, some different types of adverse documentation that we just want to explain to you and kind of describe for you so that you can get an understanding of what it is that we see from the lawyer standpoint when it comes to discovery and looking at construction files and communications. Then we want to move into how it is that you may be able to create and maintain privileges that may be able to shield the discovery of some of these adverse types of communications that may pop up, and frankly, just normal run-of-the-mill types of communications. And then finally, Jill is going to talk through kind of a loss of productivity case study in which there are some real-world examples of and discussions about failing to maintain certain types of documents. So with that, we think that the natural starting point is to understand just what kind of communications out there exist. So on these types of projects, obviously you have your formal reviewed written work product, technical memoranda, geotechnical analysis, formal written correspondence, and these types of formal communications are generally well vetted. They go through peer review, are structured, there's intentional content. And so for purposes of this discussion, we are not talking about this type of communication. What we are instead going to talk about are the casual, informal communications, again, which Vlad had alluded to, which can oftentimes get you into trouble. And so when we talk about these types of informal communications, what we're really, zeroing in on are forms of communication such as email, which everybody is obviously aware of, text, and now, given the rise of kind of remote working environments at some level, instant messages, so otherwise known as IMs. So platforms such as Teams or Skype, in which colleagues can actually chat with one another, either on a group chat or send individually to other participants. So before we get into really the forms of communications and some of the problems that we see, what we wanted to do is just provide a little bit of a baseline understanding of the reasons why we're sensitive to these communications. A lot of folks that work with public entities think, oh, well, yes, there is some transparency through what is called the Public Records Act request, where any person from the general public can simply ask a public entity for certain types of records. So those types of requests usually are going to be called Public Record Act requests, or PRA requests. PRA requests are very different than the type of discovery that exists in a civil action. And so when we're talking about, excuse me, when we're talking about civil action discoveries, what we're not sure what's going on here. My apologies. So the civil, oh my gosh. Let's do that. So civil action discovery is really going to take the form of document requests, interrogatories, depositions, those types of things. And so your communications on a project can actually get swept into those modes of discovery on a civil action matter. So real, kind of back to basics with respect to PRAs. So there is a myth out there that, not a myth necessarily, but there is an understanding out there that certain types of documentation is not subject to discovery under PRA requests. And the one that folks most often cling to are drafts. So for instance, if you have a draft document, people take comfort in the fact that, okay, if there's a PRA request about this particular project, this will never see the light of day. So I can actually just write whatever I want, keep it in draft form, and it will never, ever be discovered. And there is some legitimacy to that because Government Code Section 6254 specifically exempts drafts or memoranda from PRA requests. So, there are, some bases on which to have that sense of comfort. However, when we turn to the civil discovery side, Section 2017 of the Civil Code or the Code of Civil Procedure says that any party maintain discovery regarding any matter not privileged that is relevant to the subject matter involved in the pending action. And what this means is that the liberal standards in discovery are very, very broad. And it means that you're able to reach into pockets of information that you may not be able to access even under a PRA request. And so one of the things to be really important, or to be really cognizant of, is that within civil action discovery, e-discovery or electronic discovery is now far more prevalent than it's ever been. People are starting to really drill down into the kind of reservoirs of information that people have, whether it's on their telephone, whether it's on their personal laptop computers, whether it's text messaging. These types of things are becoming fair game in discovery. And so really kind of the modes of informal communication are no longer unknown, and they're being actively sought after by attorneys in discovery. So the takeaway here is really that civil discovery is very broad. And importantly, there is no draft exemption or exception in discovery. And that means that even though somebody took comfort in the fact that a draft document may not be discoverable under a PRA request, it is discoverable under a civil action discovery standard. So it's really important to educate your staff and employees on that distinction. If you are utilizing instant messaging, you just need to understand that lawyers are going to find it. They're going to ask for it, and they're going to look very intently at it. So the first area that we were really going to talk about, again, are these risks of employee behavior. And so imprudent communications that may be discovered. The first example of that is this casual instant messaging. And so things to just simply be aware of and to tell your staff about. Instant messaging chat sessions don't disappear. There's a common misconception that when a Teams meeting is over, if there's been chat sessions within that Teams meeting, once the Teams meeting is over, that chat session just disappears. It doesn't. It actually usually is stored somewhere on the Exchange online mailbox in whatever IT server arrangement supports that particular system. And oftentimes, what you'll see in a lawsuit is that one of the attorneys is going to issue what is called a litigation hold letter to opposing counsel, instructing them to instruct their client that they are duty bound to preserve all communications across all platforms. And so that involves actually eliminating and pausing any sort of automatic destruction that may occur to emails or whatnot. So you are now duty bound to actually preserve that information. So those chat sessions that we talked about before, which people sometimes think are private, are going to be preserved and they are discoverable. So here is an example of a messaging chat that that we discovered in a case, and it wasn't construction related, but I think it's pretty emblematic of the problem. So Wes is one of the employees writing to RI, and he says, why was Bugs running inventory reports and copying the whole company? Now, Bugs was a nickname that these two folks in this chat session gave to their CEO. I'm sorry, CFO. And so the CFO, Chief Financial Officer of the company, apparently ran these inventory reports. Well, Wes's text friend here says, because Bugs is an idiot, I saw that this morning and just shook my head. He then asks the question, are the distributor inventory reports accurate? And Wes responds, no way. Now, why was this particular instant chat really interesting for us? It's because in this particular case, my client was alleging that the vendor that it had used in order to track its inventory had misallocated certain inventory and had basically kept faulty inventory records. And so this innocent chat between two guys in a meeting suddenly became kind of an epicenter in the case because it established that the inventory reports, which we claimed were inaccurate, were deemed inaccurate even by these own employees. And so it really became a very, very, kind of piece of, a very, very weighty piece of evidence in this particular case. And so we used this in deposition and actually got very, very good admissions from folks, all because of a string that two guys on a Skype session, actually, I think is what this was, never thought would see the light of day. Another one, again, a Skype IM, also not in the construction context, but it was in a software case that I was involved in. And this was a Skype IM that we discovered amongst our own employees. So, it's somewhat self-explanatory, but it basically established that the software implementation was completely messed up. And the problem was our employees were involved in the implementation of this software. So this was obviously a communication that we were very disappointed to see. And again, it was, a communication that folks just casually had over a Skype session that they never expected to see the light of day. I guess the takeaway here is it's really important to educate your staff and employees on the risks of these types of casual conversations in IM threads. And these are just a couple of real world examples of how they can actually be used down the line. So another kind of imprudent communication form is the use of social media at a job site. So everybody is on social media. It is, just, I think, a go-to kind of habit for folks when they have a couple of moments break, on a construction site, wherever. And some of the obvious cons of social media use at work are going to include, less worker productivity. But one of the ones that, is becoming an issue, more of an issue, are the potential security risks. In other words, the social media serve as a gateway, particularly if it's on an employer's device, of actually introducing malware or ransomware. And so, there are impacts and consequences to that. There's also an increase of the risk of legal liability. So if you have employees who are using social media to harass other employees on social media, that just creates potentially risks. Same with disparaging an employer. If you have an employee who's using social media and they badmouth their employer, and then for whatever reason, whether right or wrong, are terminated, that employee has an opportunity to claim some sort of retaliation. So it's just important to educate folks about the dangers of using social media at work. So this was a real world example of social media at a project site where an employee was videoing the conditions at a particular site, specifically trenching that was involved in the installation of piping that was going to be used within the project. And what happened was this employee actually posted video on social media of the conditions of the project site, which served as pretty strong evidence that the contractor had failed to put in a frame. And so all of a sudden now you have a situation in which the social media post is serving as really a gateway to criticism about whether there were safety plan violations on the particular site. And so all of this to say that there is value in considering whether or not, as an organization, you want to adopt policies that actually restrict the use of social media, and certainly prohibit the use of unauthorized recordings of anything on site. And so obviously enforceability is always tough in that circumstance. You can't watch every employee for every single moment, but to the extent that you adopt some of these policies, it can be helpful in perhaps being able to minimize the frequency with which it happens. So moving on into other types of employee behavior that can create risk. One of the big subjects that we've talked about today is obviously adverse documentation. And so there are different types of adverse documentation that we're really referring here to. For instance, internal bickering, candid self-assessments, and criticizing other teams or other team members. And so we'll walk through just some examples of each. But before we do, just a teaching point. It's really important to educate employees about what the purpose is of any communication that they want to write. And some of the questions that they ought to be asking themselves is, why am I putting this in writing? Do I need to put this in writing? Is it something that can be addressed with a simple telephone call? And the reason why is the moment you put something in writing in today's digital world, it's never going away. It's there permanently. And so it's just important to just have a moment's thought about, why is this going, to be put in writing? And also, who are you sharing it with? Who's the audience for this? So you just want to be really cognizant of that when you're writing things. And again, what is the purpose and nature of the communication? Why are you sharing it? Is it to actually inform somebody about something? Is it to get clarification on something? Or is it for some other purpose, such as, griping or just venting? If it's the latter category, it's really important to pause and, perhaps not put it in writing, or perhaps not hit the send button. And we'll get into some examples of written communications in which people perhaps shouldn't have sent, them to the recipients. So internal bickering. Here's some real world examples. So this is an email which was sent by a construction manager complaining to somebody else on a team. Hey, the email that you sent me is an inappropriate email. Address me and I'll deal with our managers. Addressing the PM only shows that you do not trust what I'm telling you. This is one of my biggest concerns. It sounds like you don't believe me and this email will magically fix something. Again, not super, inflammatory, but this is an example of the type of communication which really serves no purpose other than to just kind of vent about an issue. And it's nothing, that couldn't have been addressed in a simple telephone call. But the reason why this became an interesting email for purposes of our situation, in which we, as the project owner, were involved in a dispute with the contractor, was that we were able to establish that this started to create some dysfunction, or at least the appearance of dysfunction on the contractor side. And so, again, anything that pops up in emails like this, lawyers are going to use in order to establish that the project team, at least in this particular instance on the contractor side, was having internal issues. And anytime you have internal issues and friction, the project just doesn't run as cleanly. So although this email alone may not be all that mind-blowing, if you package this with 50 other emails like it, you can actually start to really tell a story. Another category of adverse documentation is the candid self-assessments. So here's an example of an adverse self-assessment. This was, again, on the contractor side, an internal self-assessment of the management team. And the ones that I love the most here are actually in the middle. Lack of decision-making in a timely manner. Management is far too in the weeds and missing the big picture. Micromanagement, coming across the owner as brash, arrogant, and non-cooperative. This type of email is absolute gold to a lawyer who is trying to establish that the other side's team just wasn't functioning correctly. And when you start, getting communications that talk about lack of decision-making, particularly in a complex project, and you're dealing with claims of delay, that type of email or self-assessment is absolute gold. So takeaway here is it's always important to self-assess. Self-assessment and kind of internalized evaluation is really positive. But are there ways that you can do it without creating liability? Can you have self-assessment groups or roundtables that aren't put in writing? And if it is going to be put in writing, are there ways that you can protect it? And one of those ways could be cloaking it in some sort of privilege, attorney-client privilege or attorney work product or something like that, which we'll talk about in a few minutes. Another teaching point that you can share with employees and staff is, kind of stay in your lane. If you're an employee and you're looking to write something to somebody, what is your relationship to the information? Are you the best person to send this information? Is it based on your personal knowledge? Are you simply, kind of conveying what you think you heard? Or are you just offering up something for the sake of offering up something, whether it's, known to you or whether you're speculating? And if it's the latter, you really don't want to put it in writing because your own opinions, own speculations can actually come back to bite you. So if you're writing from personal knowledge or you're conveying what you have heard from somebody, that's, that's fine generally, but you don't want to guess. And you certainly don't want to put opinions, uninformed opinions in writing. Along the same line, when you are putting things in writing, you want to avoid characterizing wrongdoings or validating the adverse party's kind of positions or conclusions. For instance, you don't want to say, hey, you know what? Yeah, there's some delays on the project, but some of it really kind of probably was our fault. Not a good thing to have in writing. You want to be careful about sensationalizing a condition or a dispute. You don't want to talk about it in, big brash terms. You want to make certain that you are being balanced in how you describe things. Asserting facts in absolute terms. What that means is you don't want to put into writing facts that are very hard to walk back down the line, or positions or conclusions that are very hard to walk back. If you say the sky is blue, and you put that in writing, then people are going to hold you to that statement. Maybe it was cloudy that day, and maybe you don't really know, but the fact is you put it in writing, and it therefore, for some purposes, becomes truth. You don't want to guess about facts or reactions. And finally, you want to really avoid reaching conclusions about issues that are in dispute. Again, at the beginning of this slide, talked about, yes, there may be some delays, but some of it was our fault. Well, that's reaching a conclusion about a potential issue that is in dispute. And again, if that's in writing, it becomes gold for the attorney who is on the other side. So a third type of adverse documentation is going to be criticizing other teams. So on these types of large construction projects, you always have multiple teams. You have project manager teams, you have construction manager teams, you have design teams. And so oftentimes there can be some friction between some of those teams, and you want to avoid daylighting some of those frictions. So this is a long email, which we found. I'll try and summarize it quickly, but it's again a construction that is just fed up with folks, from the project management side, who are just dragging their feet on the project. And so some of the choice language here is, this is why I've been going through this BS for a year. I'm fighting for everyone I'm fighting with has been removed from the job, and here I am again dealing with somebody else's BS. Since last Wednesday, a week, your CM, has had to deal with this just to get the tools to make more money, and so it just kind of daylights some of the friction between these parties. Excuse me. And so what you're seeing is, an assertion that engineering and procurement isn't supporting the CM team. And again, that's just pure gold for a lawyer. What are the issues with respect to this particular communication? In many respects, it was pointless. The only purpose for this particular email was simply to gripe. And what it does is it establishes dysfunction on the team. It demonstrates that there's a friction between different units, within a project team. and again, what that creates is a narrative that opposing counsel can use in order to establish dysfunction, in order to establish that the project team or the construction team isn't in sync, is itself the cause for delay. So again, those are just unnecessary communications. Also, just as a little throwing point, anytime an employee uses profanity within a communication, again, that's kind of a lawyer's dream, because it just sensationalizes the issue, which is huge. Oh, did I just lose the share?
Yes, David. Yes. We cannot see it.
That is odd, because my share is now locked.
Vlad, it said only meeting organizers and presenters can share.
Okay, let me see if there's some issue, technical issue. Let me see. Did that?
Yeah, my share is still
How about now?
Well, oh, there we go. Yep, it just went. Thank you. All right. All right, can you see that again?
Yes.
Yes.
Okay, perfect. All right, here's another example of teams kind of pitted against teams at a certain level. So this is an email, again, a real world example. Writing is evidenced by the amount of PCOs and drawing revisions. The design is incomplete and flawed. Designer has issued 6 design modifications, totaling changes to 334 drawings and an additional 50 sheets. Designer is working on DM 7, 8, and 9. I mean, all of this stuff is true and it's factual. And to the extent that it's being communicated, all the author, I think, really intends to do is just simply provide some context for the reason why there's some issues here. But what are the problems with this particular communication? The biggest problem, again, from a lawyer's perspective, is that this author has actually come to a conclusion about the designs. Specifically, the design is incomplete and flawed. And the problem is he's talking about his own team's designs. So again, this is a real world example of somebody who has created now a very hard statement to walk away from. So in deposition, when confronted with this language, a lawyer is able to say, you design was incomplete and flawed, right? Those are your words. And you did so knowingly because you wanted to communicate that to the sender. So a lawyer is able to take a writing, draw conclusions from it, and then actually use those conclusions in order to establish the proposition that they want to establish, which is that the design was problematic and that as a result, it's what created delay on a particular project. So again, if one were to rewrite this, you would want to do so in a way that eliminates, at a minimum, those conclusions as fact. So I mentioned earlier that there are some ways to cloak certain types of communications, in some sort of privilege in order to avoid them being discovered. Ways that we'll talk about. Before we do, privilege is essentially a category of communication or work product that isn't subject to discovery under either a PRA or under a civil action, discovery regime. And so the types of privilege that we typically see are attorney-client communications and attorney work product. Attorney-client communications are, as the term suggests, communications between an attorney and a client. And the reason why those are privileged is because the law recognizes that attorneys and clients need to have frank and honest discussion. And if those discussions were subject to discovery, it would chill communications between a client and his or her attorney. And so they vest that in privilege. Attorney work product materials are essentially work product that is generated at the request of an attorney in connection with a pending or anticipated litigation. So if, for instance, Jill recognized that there was a dispute on a project and wanted certain information, she could ask a project manager, for instance, hey, are you able to actually isolate this type of information for me so that I can get a sense of, what's there and what has been said about this? And to the extent that that information is actually gathered, it would be deemed to be work product because it was generated at the request of an attorney. So those types of privileges and doctrines can really serve as a shield against communications and work product being discovered. So some of the easy ways to cloak some of these communications that we've talked about in privilege is perhaps to just simply mark the documents directly. And so, for instance, if certain types of information have been requested by an attorney, when those documents are generated, you can simply just stamp them with attorney work product. And if the attorney that you're working with has requested them, hopefully what they'll tell you is, look, just send it to me in an email, have the email subject line say attorney work product, stamp the document attorney work product. That way there's no real confusion as to what this is if and when some PRA request or civil discovery request is made. It's easy to identify. And because it's easy to identify, hopefully it's never shared. And if it is shared, then the other side has a general obligation to actually alert you to that and to return it. So it's a valuable footer to have. Other ways that you can actually create zones of privilege are to create physical file management systems. So if you're not purely kind of in digital document mode, you can create physical files that actually physically separate attorney work product materials from other types of materials. And so that becomes just an easy visual organizing principle to know what is privileged versus what isn't privileged. Another way that you can do it is you can create color-coded folders, red for privilege or some other color, binders and whatnot. And so you can keep all of your privileged materials in a color-coded file or folder. Another way to do it is to create electronic file management systems. So if you have folders on your system, you can simply title them attorney work product. And that way everybody knows that attorney work product has a specific destination in your file structure and can just drop materials directly into that folder. And then finally, with respect to communications with counsel, if you have direct communications with a lawyer, then generally speaking, your communications are going to be pretty self-evidently privileged, because it's clear that it's going from the client to the lawyer. Another way that you can actually direct things directly to legal counsel is to hand deliver things. And that way that legal counsel has them in hand and there isn't any chain of custody issue. If you don't have direct connection with then what you can do is you can actually route communications or work product through supervisors and have them actually loop counsel in. And so, those are just some different strategies on how it is that you might be able to vest communications with some degree of privilege. And now I'm going to turn it over to Jill, really to talk about kind of her case study in the world of loss of productivity. So with that, I'll turn it over to Jill.
Thank you, David. So can you go to the next slide, please? So I'm going to run through this case study quickly so we leave some time for questions at the end. But what I will say is if you're interested in more information about loss of productivity, is we have a detailed, it's about a 90-minute training on this particular topic. And I'm also happy to answer any questions. So the reason we pick loss of productivity as a case study on documentation is because it is a claim that we tend to see when a project is struggling or having multiple issues. It's very document intensive, both from the claimant's perspective, so the contractor's perspective, as well as from the owner's perspective. And that is because it's one thing to say there is a productivity issue on a project, and it's a very different thing to prove it. That requires not only showing contractual liability, but also causation. And that tends to be a sticking point in an area where an owner can prepare documentation and really undermine the causal leg of the claim. Next slide. So here's a decision from one decision-making body about causation. I really like this quote because I think it sums up how courts generally look at this issue. Again, emphasizes the contractor must demonstrate causation, or in other words, that a particular work activity was impaired by an action taken by the government. The second bullet point is also interesting. So the causation can be the result of one change or action by the government, or the cumulative impact of a group of undifferentiated changes. And it's this latter part that can be particularly difficult to manage. For example, if there's a lot of design changes or other issues on a project, a lot of times you can see a loss of productivity claim that's basically the kitchen sink approach. Everything that the owner did created productivity issues. Next slide. So there are many different approaches that contractors use to establish loss of productivity. I'm just going to highlight a couple key points related to each one. They're listed on the bottom: total cost, industry studied, and measured mile. Again, each one must still determine cause and effect and must quantify the losses. Regardless of methodology, those are still required. Next slide. So first is the total cost approach. We actually see this quite frequently, even though it's a disfavored method for establishing damages in California. It's still a valid method, and it's easiest for the contractor to put together. So it's essentially total cost, total actual labor hours minus bid hours, and that's the claim. There are many ways that this could falter. In particular, the contractor must establish that all of the additional cost was caused by actions of the owner. And again, that's an area where there's fodder for undermining the contractor's claim, particularly if you have good documentation on the project. Next slide. The next methodology that you'll see less frequently is industry studies. This methodology used to be more popular. These industry studies at this point are just quite dated, but they basically establish various percentages that you can use to estimate productivity issues. And again, they're dated, and also these studies are based on limited sample sizes. So usually these are undermined specifically with expert testimony based on project documentation. Next slide. And the last is the measured mile. This is widely recognized as the most reliable methodology for loss of productivity. So in this case, the contractor will take a portion of the project that was purportedly least impacted by the owner's activities and compare it with actual performance. So in this case, documentation is still very important, because the owner can then challenge whether the test case, so the relatively least impacted area, is in fact a valid measurement compared to the actual performance. So next slide. So again, what can the owner do to best defend itself? And if you go to the next slide, David, the answer is documentation. We have worked with our various clients on conducting an audit or review of project level documentation. But really the key is, particularly if you anticipate there being a significant delay or productivity claim, is making sure that the owner has its own documentation that's taken contemporaneously, which means it's the dailies, it's the documents that are created at the time the events occurred, the who, what, when, where, and why that's going on in the project. For example, including in daily reports issues that the contractor has caused, along with photos, so you can easily reference what's going on and find the photos that go along with the particular issue. Another way to document this is in response to schedule updates, for example, to list not necessarily critical path delays, but have area managers comment on project delays or inefficiencies that are caused by the contractor's own actions, so that every month you have contemporaneous information about what was actually going on the project. And as you'll see the last note, the best documentation usually wins. So having robust documentation that was created at the time can be very impactful if there's a dispute later on. Next slide. Why is that the case? The first one is very important. Memories fade. In these really fact-intensive disputes, it's very difficult to recreate what happened multiple years ago. Disputes typically take that long to really percolate and materialize. The delayed documentation can result in loss of critical details. You may have thousands and thousands of pictures on a project site, and if they aren't linked to issues in real time, it can be really difficult to go back and isolate and find photos of the issue that you're thinking of. And then sometimes there can be employee turnover as well that can really help limit your ability to investigate what happened multiple years ago. Next slide. And finally, yeah, it popped up. Thank you, David.
Oh, sorry.
A final point on this, but I think is really important. Robust documentation can help mitigate disputes as well, because it fosters transparency and also just helps the parties communicate and understand and assess risk in real time. So we do think that it's beneficial to both sides. And with that, Vlad, I'll turn it back to you.
Okay, well, thank you so much for a very insightful presentation. We'll turn it over to Chris for Q&A. Chris, I think we have some questions in the chat.
Okay, the first question, companies that allow artificial intelligence to access their internal databases, listen to devices like smartphones, record videos, will make it easy for a paper trail. Should AI be used at all?
Huh. I mean, I think AI is coming. Well, not.
David, I think we lost you.
Is. Oh, are you there?
Yes, we can hear you now.
Oh, okay. Sorry. Yeah, I think AI is inevitable, and it's going to be incorporated into everything. And so, at some level, I do think that while it creates paper trails, it does still create, potential, I think, document maintenance issues. And, I don't know necessarily how it will get incorporated into in documentation retention. But at some level, there are still human factors involved. And so I think, the AI is an interesting kind of point to consider. But I think in terms of eliminating risk with documentation, that's probably some ways off.
And I think what I would just add is one feature where we discussed AI is recording or creating transcripts of meetings. And similar to chat, those transcripts can be really problematic. It's one thing if it's a transcript of an important external meeting or a recording of a presentation, but if it's an informal internal meeting, typically we recommend not to turn on those transcript functions or not to retain them for a significant period of time, because like chat, there can be really informal off-the-cuff statements, and to a certain extent, when you're working, you have to be able to have those informal conversations to move the business forward. And so that's an area where we do see there being some attention put on not saving those materials.
Thank you. Chris?
How do you recommend balancing the need to reduce the risks of written communications with documenting what occurs on the project?
Do you want me to jump in that one first, David?
Sure.
Yeah, so we didn't have a chance to get into documenting what goes on a project in a lot of detail, but the documents tend to be different. So the documentation about what's progressing on a project tends to be records that you establish. For example, meeting minutes, daily reports, responses to submittals, comment logs, RFI responses, non-conforming work responses, those kinds of things. It's very important that those are accurate, and then they're also robust. Depending on the scale of the project, right? So you're going to have a lot less documentation on a $2 million project versus a $1 billion project. But that's really different than the internal emails and chats, which is what David was talking about. So when you're thinking about documentation of what's going on in a project, think, what is the contractor representing to you about what's going on? What is actually happening in the field? That's what should be recorded. Internal concerns, bickering, those are the issues that tend to create problems for the agency rather than assist them.
Thank you. And then, Chris, I think there's another question in the chat from Kyle.
Yes. So this is a hypothetical scenario. Assuming that there is a discovery in a case where on the project they're having construction trailer coffee table replacement that in practice may only involve a handful of employees who worked on that project. To what extent can discovery be used to collect private or personal communications from employees who weren't involved, such as painters or a gardener? And who makes the determination as to what employee communications should be subject to e-discovery requests instead of a blanket request all of the employees?
Yeah, it's a very, very good question. And what it kind of raises are issues of discovery of business records and project records versus privacy concerns about somebody's personal records. And so generally speaking, what you see is a court curbing the ability to just have complete access to an employee's telephone, their texts, their emails, their personal emails. And usually what happens in those circumstances is to the extent an employee is implicated in the underlying facts and to the extent that employee might have records, questions will be posed. Did you ever create any sort of work emails on your private email account? Or did you use your personal phone to text about business matters? And if the answer to those questions are yes, that you have somehow kind of commingled your personal email addresses or devices with some work issue, then usually what will happen is there will be perhaps a pullback of information from a telephone or an email server. It will be reviewed by whoever is representing that employee or the business, and everything which is personal tends to get weeded out, and anything business related may then be produced. But the real threshold issue is whether or not the employee has used their personal emails or devices in the first hand. So the question is a good one because there may be value in instructing or at least informing and educating your staff and employees. Look, keep these things separate. Keep your work devices only for work. Keep your business or your personal devices only for personal, and try not to mix the two, because what can happen is your personal device can get swept up as part of the discovery.
Thank you, David. Unfortunately, I think we're running out of time for questions, so we will circulate the responses, and the recording of this video will also be posted on our website. So today's discussion reinforces something that we all know but don't always think about in the moment. Everything we put in writing, whether it's an email, field report, meeting notes, or even instant chat, can become the part of the official record. So my key takeaways for today are: write with purpose, not casually or emotionally. Stick to the facts, avoid assumptions or opinions, and don't speculate. Be consistent in your documentation, and most importantly, assume everything you write could be reviewed later by attorneys, arbitrators, or even media. So thank you everyone for joining us today, and a big thank you to our presenters for sharing their insights, experience, and practical guidance on navigating written communication on construction projects. We hope to see you again for our future webinars. Next month, as we mentioned, we will have an open forum with some spillover discussion from today's topic. And please stay tuned, and we will be announcing additional webinar sessions coming shortly. Again, thank you very much. Thank you, our dear presenters, and have a great day, everyone.
Thank you.
Thank you.